Hello, and thank you for checking out another one of the panels for our conference. It's a panel that I'm sad that we've added to the conference, but that I'm also thank the panelists that are joining us today to talk about the legacy of Justice Ruth Bader Ginsburg and what she meant for the LGBTQ community. I'm going to do some quick intros, and then we're going to dive in. Shannon Minter is the legal director for the National Center for Lesbian Rights. He's had extensive involvement in LGBTQ impact litigation over many decades. He was, for purposes of our discussion, he was extensively involved in marriage cases in California, and also was NCLR's lead attorney in Christian Legal Society versus Martinez. David Codell is in private practice at his namesake boutique law firm based in West Hollywood. He clerked for Justice Ginsburg in 1996 through 97. He's had stints at the Williams Institute and NCLR, and was also very much involved in marriage equality litigation. Joshua Matz is a partner at Kaplan Hecker Fink. He clerked for Justice Kennedy in 2014 through 2015. He's part of the team representing the city of Philadelphia in the case pending this term at the Supreme Court. Ria Tabacco Mar was formerly a senior staff attorney for ACLU's LGBT and HIV project, and last year became director of the Women's Rights Project at the ACLU. So I think it makes sense to maybe start with Ria and ask her to say a little bit about the beginning of Justice Ginsburg's, or not quite exactly the beginning, but the earlier part of Justice Ginsburg's career, where she was an impact litigator, started the Women's Rights Project at the ACLU. This has been sort of extensively covered in books and movies in the past few years, appropriately. But Ria, can you maybe bring people back to the 1970s and talk a little bit about what Justice Ginsburg did in the 1970s?
Absolutely. Thank you, Matt, so much for putting this panel together. As you mentioned, I'm currently the director of the ACLU Women's Rights Project, which of course, Ruth Bader Ginsburg co-founded with Brenda Feigen in 1972. And so over the past several weeks, many people have asked me how it feels to be standing in shoes that she once occupied. And I have to be candid, it's very intimidating. But one thing that is helpful to me is to imagine her not as we tend to picture her today, and as an 87-year-old woman, tiny in stature, but enormous in influence, perched on the bench, often with a sort of little offset crown on her head that became a meme, but to think about who she was in 1972. Because in 1972, Ruth Bader Ginsburg was 39 years old. She had teaching experience at Rutgers Law School and Columbia Law School, but she was just really starting out her litigation career. And she had the opportunity to do something really new and remarkable. And when you think about what that was like to be at that moment in your career, at that moment in history, it's really amazing. This is decades before Price Waterhouse and before anybody was using the phrase sex stereotypes, but really the strategy that drove her litigation while she was at the ACLU was all about sex stereotypes. It was all about the ways in which rigid gender roles harmed all of us, not only women, but men. And, she was noted for representing men in her work, and that's come up quite a bit in the coverage. One of her favorite cases to talk about was the case of Stephen Wiesenfeld. Stephen became a widower when his wife died in childbirth, and he had hoped to stay home with their son, Jason, who survived and actually raised him for those first few years of life. And he was surprised and disappointed to learn that he was not eligible for Social Security survivor benefits. Whereas had his wife survived and he had been the one who had died, she would have been eligible for those benefits to stay home with Jason. And Ruth Bader Ginsburg took on Stephen Wiesenfeld's case, and she won. And part of what she was doing by representing men, of course, was to help what was then an almost entirely male bench. Certainly when you look at the Supreme Court, you're thinking about 9 white men, but even the lower court judges, overwhelmingly male, to help you understand that sex discrimination hurt men too, right? Here's a man who was literally being deprived of an economic benefit that he would have been entitled to if he were a woman. But she was also helping them to see how this really harms families as a whole, right? Because in order for Stephen Wiesenfeld to stay home, what would that look like for him to actually be involved in his son's life? What was the alternative for him if he didn't have that benefit and he had to go out and work? And what does it mean for women whose husbands wanted to be caregivers, right? Because in order for women to have full economic liberation, men were going to have to step into those domestic roles in order for women to be able to step out of them. And importantly, I think Ruth Bader Ginsburg did not privilege one sphere over the other. She thought both parts of life were equally important. Family life and economic life were important. What she wanted for all of us was to be liberated from the stereotypes that we could be successful or that we properly belonged only in one of those spheres. She wanted men and women to succeed in both spheres. And that's what so much of her litigation was about.
And can you say something about what influence Pauli Murray had on her, and as she was, you know, in the first brief she filed at the Supreme Court in Reed v. Reed, she added Pauli Murray's name to the brief. And I know many of the folks here have worked on Supreme Court briefs, and it's not common to add people's names to cover pages on briefs. But I think for our discussion, it's so important to mention to Pauli Murray this morning.
I'm so glad you mentioned Pauli Murray, and it's been really wonderful to see Pauli Murray finally in recent years get the recognition, I think, that was long denied Pauli's contribution to both race and sex discrimination law. So as Matt mentioned, you know, the first brief that Ruth Bader Ginsburg ever filed to the ACLU in the Supreme Court was in a case called Reed v. Reed, and this involved an Idaho statute that said, you know, when a child had died, as between the father and the mother, who was preferred to be the administrator of the child's estate. And Idaho law said it was automatically presumed to be the father. And at that time, it's important to remember the Supreme Court had never struck down a law as constituting sex discrimination, 0 times. So I give you that context because you imagine putting in this brief, you have 0 authority, and it makes it all the more remarkable, but also I think important context for the decision to add Pauli Murray's name, as well as the name of Dorothy Kenyon. Dorothy Kenyon was a lawyer who had litigated and lost a case involving women being excluded from jury service just a few years prior. And Pauli Murray, of course, had been, her law school note at Howard really was the architecture of the strategy that became Brown v. Board of Education. And it was a strategy that Ruth Bader Ginsburg was very much hoping to emulate as she worked toward what she hoped would ultimately be strict scrutiny for sex-based classifications. Ultimately, she got only to heightened scrutiny, but that was very much her model. And the decision to add both Dorothy and Pauli's name to the brief, I think, has often been mentioned in the last few weeks as really an example of Ruth Bader Ginsburg's greatness because she was recognizing those who'd come before her. But I think it's also really a story of Pauli Murray's greatness. To imagine being someone who is such a giant in the field that you're filing a brief in the United States Supreme Court, you've got 0 authority, you have no case law, right? But you have Pauli Murray, and you recognize that Pauli is the one whose ideas made this advocacy possible. And so it's just such a wonderful partnership. And when I had the opportunity to meet Justice Ginsburg earlier this year, you know, she mentioned Pauli Murray to me on her own, and it was just so clear that all these decades later, that Pauli Murray's work had been such an inspiration to her. And she never forgot it, and she never wanted anyone else to forget it either.
Can I follow up on that point?
Yeah.
And say something? So I moved to California in 1999. And in 1999, there was not a single statute or judicial opinion that really helped gay people at all. But there was Shannon Minter, the National Center for Lesbian Rights, the ACLU, Lambda Legal, and we started in 1999, we drafted a domestic partnership law, and we built up marriage law. And when we went to court, we had no precedent. There was nothing in our favor. And I learned my lessons from RBG, who told me go step by step, just go step by step. And that's what we did, Shannon, right? And now then we got marriage equality in California. We lost it, then we got it back. But we went step by step, and that was the way you did it. And she taught me that.
Yeah, absolutely. I was looking for a quote that maybe would, you know, one quote that would really summarize sort of her, you know, what she stood for. And one that came to mind for me was this quote from the VMI opinion, where she said, "A prime part of the history of our Constitution," historian Richard Morris recounted, "is the story of the extension of constitutional rights and protections to people once ignored or excluded." Shannon, can you say a little bit about you know, that quote and sort of what Justice Ginsburg symbolized?
Yes, and Ria, I just want to say I know Justice Ginsburg was thrilled to have you in her former position, and we all are too. Yeah, I mean, Pam Carlin and David Cole wrote a really nice piece recently about Justice Ginsburg and made the point that with the exception of Thurgood Marshall, really there's no other Supreme Court justice who's done as much to realize our Constitution's guarantee of equal protection of the laws. And of course, that has been particularly true for gender-based discrimination, both as between men and women, the case law that Ria was just describing, also for LGBTQ people. And it's just so striking that even though Justice Kennedy, of course, ended up writing most of the big opinions that we think of in the LGBT rights arena, I think it was Justice Ginsburg who really provided the intellectual and doctrinal scaffolding for a lot of those decisions, really all of them. And her decision in the Virginia Military Institute case in 1996, I mean, it's one of the most important sex discrimination cases ever decided. She held, of course, that Virginia Military Institute couldn't exclude women, and really knocked down their argument. They argued that, oh my gosh, men and women are so different that allowing women into this institution would really destroy the very nature and character of our pedagogical method. And Justice Ginsburg was like, no, we've heard that same argument that women would destroy the legal profession, the medical profession, policing. And of course, later we heard that argument about same-sex couples in marriage, that allowing them to marry would destroy the institution of marriage. And she just kind of batted that away. But I think like three things really stand out about that decision. I mean, it's just so central to constitutional equal protection law, is that it definitively resolved the question of whether sex-based discrimination would get very meaningful heightened scrutiny. And of course, we've all cited the language from that case so many times that for the government to justify treating people differently based on sex, they better have an exceedingly persuasive justification. And then it is really a master class on stereotypes. Ria, you were talking about this a bit, but it's just some of the most concise, powerful analysis of why the government cannot ever justify differential treatment of individuals based on overbroad generalizations about how men and women are supposed to be. And David, I learned so much from you in the marriage equality cases about how to marshal that argument to talk about marriage and to say, yes, most men and women, it's stereotypically true that most men and women are only attracted to people of the other sex and only want to marry people of the other sex. But that is an overbroad generalization when it comes to lesbian, gay, and bisexual people. And then Matthew, the other really standout powerful language from that decision. And Justice Ginsburg isn't known for her poetic or flowery language. I mean, she's known for like razor sharp, extremely logical, compelling, tightly knit arguments. But I love that line as well. And it's just such a perfect encapsulation of her belief that the Constitution is a living charter and that we have to keep up with changing social conditions and recognize our evolving understanding of equality. But I do love the language about that is the story of our Constitution. It's the extension of rights and protections to people once ignored or excluded, very much including, of course, LGBT people. We saw that play out so powerfully in Obergefell, which even though it had Justice Kennedy's name on it, it certainly had Justice Ginsburg's fingerprints and handprints all over it. And I'll just say, I have no doubt that she would have recognized that same principle when it comes to transgender people. One of my, regrets is that she won't be on the court if and when the court ever, for example, resolves whether or not the transgender military ban is constitutional.
Shannon, she was on the court when the court ruled that Title VII includes transgender people. And I just want to add one other thought, because I know there are other people who want to speak. But in the VMI case, there's a famous sentence where she talks about equal opportunity under the law. And she understood that everyone should have equal opportunity under the law. And it was a glorious thing. And when she entered the legal profession, that was not the case. She changed the world.
Let's talk a little bit about Justice Kennedy's quartet of the crown jewel opinions for the LGBT civil rights movement, Romer, Lawrence, Windsor, and Obergefell. As Shannon mentioned, she was not the author of those opinions. Justice Kennedy was, but she was a key pillar of all of those opinions in terms of, Romer and Lawrence were, Romer was 6'3", Lawrence was sort of 6'3", Sandra Day O'Connor wrote a concurrence. The other two were bare majorities, 5-4. So just in terms of her vote was critical, but maybe you can say a little bit about that quartet of very important opinions, Joshua.
Sure. Well, and to echo what Ria and others have said, Matt, thank you for organizing the panel. And it's such a great opportunity to overlook, I think, to discuss what could otherwise be an easily overlooked part of Justice Ginsburg's legacy. Since she didn't have many opportunities and chose in some cases not to write separately in many gay rights and LGBTQ rights cases, it can be easy to miss just how fundamental her influence was within that sphere. And that's true, I think, on several levels. One of them is that her ideas and her very presence on the court and the sort of methods of understanding the law and its possibility that she helped bring into being in the world over the last few decades are a critical part of any understanding of how, Justice Kennedy even ended up in a position to write many of those majorities, right? Justices can have influence in lots of ways. And Justice Ginsburg's influence, beyond the court in giving leadership to and support to and helping to nurture the foundations of the entire movement that led these cases to the halls of the Marble Palace is an absolutely critical part of her legacy. And then within the court itself, I actually, it's funny, I have a slightly different view than I think maybe some others do. Justice Kennedy came to these cases and he saw them fundamentally as a story about liberty, and occasionally as a story about dignity. And to him, that was the driving force behind claims for equality by lesbian and gay people. He obviously didn't have an opportunity to rule on a transgender rights case. But when he was confronted by claims, by civil rights claims from the lesbian and gay rights movement, for him, the fundamental principle there, as in so many other parts of his jurisprudence, was freedom and liberty. Justice Ginsburg came to those cases with a different mindset. She understood that there were principles of liberty at stake, but to her, the single most important value implicated by these cases was equality. And I think at the oral arguments in these cases, it's very clear that they see both of these values at play, driving the conversation forward in this way that finally, it's funny, you can sort of see hints of equality reasoning shot through decisions like Romer and Lawrence and Windsor. It's kind of unavoidable, particularly in Windsor. It's clear that equality is doing a lot of the driving, whatever the rhetorical force of the references to liberty and dignity. And then in the Obergefell decision, Justice Kennedy really brings it to the fore and makes it clear. And he says, look, this outcome is compelled by principles of liberty, but it's also compelled by principles of equality. And in the sort of second holding of the opinion, he brings them together and he says that there's a symbiosis. And he actually looks back over Justice Ginsburg's legacy. There's this kind of amazing part of the opinion where he reconfigures her equality jurisprudence as part of the story of freedom. And he says, in interpreting the Equal Protection Clause, the court has recognized that new insights and societal understandings can reveal unjustified inequality within our most fundamental institutions that once passed unnoticed and unchallenged. Now, obviously, hearing that, you can't not think of what Justice Ginsburg wrote in VMI, as we all just discussed. And then he uses that sentence as a springboard to talk about the sex equality cases from the 70s and 80s, many of which Justice Ginsburg brought and argued and won, and essentially says, like, those cases not only secured equality, they made people freer. They made men and women freer. And those cases show us how Justice Kennedy's, as it were, language of liberty and Justice Ginsburg language of equality ultimately come together to support the outcome that we see in Obergefell, a point that had been implicit in so many of his prior opinions, and that becomes explicit there. And so, I think in looking at Justice Kennedy's sort of famous quartet of gay rights cases, Justice Ginsburg's vote mattered, her stellar advocacy at oral argument mattered, her influence beyond the court in helping bring the movement to life mattered, but the ideas that she represented and that she helped write into the law are shot through those opinions in a way that comes out most starkly and I think elegantly in the Obergefell case.
I wanted to talk about one case that sort of fell in the middle of that quartet, and that is Christian Legal Society versus Martinez. It is the only, LGBT rights opinion majority opinion she was able to write during her tenure on the court. It's not as famous as the other four, but I want to remember it today, and I want to go over to Shannon for this because he was on the legal team driving that case, and sort of ask you to bring us back to that time and explain to us what that case stood for.
Yeah, thanks, Thomas. Yeah, it's actually, quite an important case, and it is the only LGBT rights decision that Justice Ginsburg ever authored back in 2010, and it hasn't gotten as much attention as Lawrence and Romer and Obergefell, but it's especially as the court is grappling now with more cases in the pipeline to sort of address the tension between religious liberty and free speech claims on the one hand and anti-discrimination protections for LGBT people on the other. It warrants some attention. Justice Ginsburg, or the court, held that Hastings Law School, the public law school, could require officially recognized and funded student groups to admit all students to basically adhere to anti-discrimination requirements, including prohibition of discrimination against students based on other students based on their sexual orientation or religion. The Christian Legal Society wanted to be able to exclude gay students and also wanted to be able to exclude students from other religions. And the court said, no, it's fine for a public university to impose generally applicable, viewpoint neutral, anti-discrimination restrictions on officially funded and recognized student groups. And two really important points that then come out of that case. And one is that the court definitively rejected the argument that CLS made that we're not actually discriminating based on a gay person's status. We're just discriminating against gay people's conduct. Like, it's fine you can join Christian Legal Society if you're gay, as long as you renounce any acting on your sexual orientation. And the court's like, no, that is not a meaningful distinction, that the status and conduct of being gay are inextricably intertwined, and we're not going to allow you to sort of pry them apart. I can't stress enough how important that has continued to be, because that is an argument that many people still advance to try to justify discrimination against our community. And we're seeing it now with the transgender military ban, where the government literally is adopting exactly that same argument with respect to transgender people and saying, oh, it's fine, you can be transgender in the military, you just can never transition, you can never live congruently with your gender identity, you must always live as a member of your birth sex. So having that strong precedent there is very helpful. And then just real quickly, the opinion also makes it so clear that whereas the government, of course, couldn't go around restricting what private expressive groups do, if students just want to start a club and that they're free to express whatever viewpoints they wanted to include or exclude whoever they want. But because there's government funding, because it's an officially recognized and government funded club, then the government can impose viewpoint neutral limitations on the clubs. So it's no surprise, given that part of the ruling, that this decision was cited by the district court in the Fulton case and by the Third Circuit in the Fulton case. And it's just going to be a very important precedent as the U.S. Supreme Court addresses the issue in Fulton, which is whether a religious adoption agency that's receiving public funding can invoke religious liberty to obtain an exemption from anti-discrimination requirements. So yeah, CLS is a little bit of a sleeper case, but it's one whose importance I think is just only going to become increasingly apparent.
One thing
Well, Shannon, just to add on the sleeper case issue and adding to the Third Circuit. So one of the things that justices of the U.S. Supreme Court do is they deny review of cases that say great things. And so Shannon brought two cases, one in the Ninth Circuit. Well, he didn't bring them, he defended them. He wrote statutes in both California and then in the Third Circuit that protected people from change your sexual orientation. SOCE is like sexual orientation change, whatever.
Conversion therapy, or colloquial known, yeah.
Okay, so Shannon successfully brought cases in two different states and won in both the Ninth Circuit and the Third Circuit. And the U.S. Supreme Court denied review. And so part of what justices do is they deny review. And Justice Ginsburg was key to that. So I just want to throw that in there because now it's become pretty standard for states to start banning these laws that try to, that would otherwise enable therapists to try to change the sexual orientation of young kids. And Shannon is the pioneer of that. And he won in both the Ninth Circuit and the Third Circuit, and the U.S. Supreme Court denied review. And that's important.
One other point I just wanted to make about CLS, just from rereading her biography this weekend, she actually announced the opinion from the bench on June 28th, 2010, the day after her husband died. And it was probably, I imagine, one of the worst days of her life to show up for work. But it just, a point that's often made about is her commitment and dedication to her job. And it's just amazing to me that she came to work that day and announced this opinion on such a difficult day. I think it's just an amazing other point to draw out here. Again, she didn't directly write the marriage equality opinions, but in 2013 she made quite a big symbolic splash, I guess you could say, in other ways. First of all, during the Windsor oral argument, this is sort of it seems almost like ancient history now, but she really, it's sort of the moment she started to go viral on social media and really became sort of cultural, really got revived or emerged as a cultural icon. And it was a question where she referred to the then state of marriages for gay couples as being, with DOMA still on the books, as being skim milk marriages. Can you talk about that moment, Ria?
Sure, and I just want to say, I think you're exactly right that was the start of the Notorious RBG movement. And, most people sort of credit, oral argument in Windsor was heard in the spring of 2013. And then, of course, the decision came out in June of 2013. And then, the same week that Windsor was decided, the court also decided Shelby County versus Holder, which of course is the decision where the court struck the preclearance requirement of the Voting Rights Act. And it was Justice Ginsburg her dissent in that case where she said, throwing away the preclearance requirement because you don't see discrimination is like throwing away your umbrella during a rainstorm because you're not getting wet. And that line, I think, really launched the Notorious RBG Tumblr and became a meme. But it built on that moment just a few months earlier that you described, Matt, where she described the marriages of same-sex couples as skim milk marriages. And both of those comments, I think, really reflect a skill that she had, which was to translate what could sometimes be arcane legal problems into language that was very understandable and real and concrete. When you think about the Voting Rights Act, who knows what preclearance was? Did anybody, who was not a civil rights or even a voting rights attorney know what preclearance was before Justice Ginsburg wrote that dissent in Shelby County? I don't think they did. And she had a way of describing it that made people understand the significance and understand this was not some sort of bureaucratic hurdle they had to jump through. Rather, it was this really core protection that actually was protecting individuals. And I think her comments in the Windsor argument, coupled with that dissent in Shelby County, also feels so significant because I think for many people in our community, the week that Windsor and Shelby County was decided was a very painful one. Because on the one hand, we had the court recognizing the profound animus against our community and striking down the Defense of Marriage Act, something that had been, many, many years in the making by so many advocates, including folks on this call. And then at the same time, you had the court turn around and say, okay, we know what discrimination looks like. And what it looks like is Congress passes a statute that calls you out, that's discrimination. And when we see discrimination in voting, that's not discrimination. We know what it looks like. And that's what's happening over here. That's happening to this community and it's not happening to this other community. And that disjunction, I think, so painful and felt so divorced from the reality of what life is like for those of us on the ground, including, of course, LGBT people of color, LGBT voters, LGBT people in Alabama, right? So we occupy all of those spaces. And I think her comments at Windsor, coupled with her dissent in Shelby County, really just showed that she understands what the impact of these decisions are going to be on individuals. What this really means in practical terms for those of us who are living on the ground, not on the court. It was never academic for her. And her ability to translate those sort of academic problems in a concrete way, I think, is what launched her RBG status.
Can I tell you a personal story that follows up on your point, Ria? So I clerked for Justice Ginsburg 24 years ago, a long time ago. And so she became a lifelong friend of mine. And every time she saw me, she would draw me into the corner of a room and she would say, "Did you see the opinion of the South African Supreme Court? Did you see the opinion of this court?" She cared so much about LGBTQ rights that every time she saw me, whatever had just happened in the last week or 2 weeks, she would draw me into the corner of a room and tell me, "Did you see what happened?" That she was a friend to us.
She also, in 2013, pre-Obergefell, started officiating weddings for same-sex couples in her sort of, I believe they were all people in her circle of friends. David, can you talk at all about, if what went into her thinking about starting to, officiate these weddings? It was really a powerful statement. She knew how much, the media and, the world was really following her sort of public moves like this, and it really made a difference, I think.
So, courage is a word that would describe her for her entire legal career. Courage. She stood up for what she thought was right. And of course she would officiate weddings. She cared about people, and she wanted to make sure that gender, sexual orientation, transgender status, nothing hindered you in any way from achieving what you wanted to. Equal opportunity, which for her meant both job opportunities, but also family opportunities, the opportunity to form a family. She cared about it. She cared so much about family dynamics. And though she had no reason to particularly care about LGBTQ people because she was, a heterosexual woman, but she did care. She wanted everyone to be able to form a family and to be able to support themselves, and she cared about economic opportunity, she cared about healthcare, she cared about everything about making it possible for you to live your life. Equal opportunity is what she cared about.
Let's fast forward again to Masterpiece Cake Shop in 2018. This is another chance where she wrote something with her name on it. And I know, Ria, you were on the legal team in 2018 for the gay couple that was denied their cake at Masterpiece Cake Shop. And I think the dissent she wrote in Masterpiece Cake Shop is actually very, very important for what it said. Can you remind us about that, Ria?
Sure. So I love Justice Ginsburg dissent in Masterpiece Cake Shop. And, this case was decided 7-2. So quite a few of the more liberal members of the court's wing chose to join the majority opinion, no doubt for, well thought out and strategic reasons. But it's notable that Justice Ginsburg did not. And I think, it was, when you think about Masterpiece Cake Shop, this is a case that it was easy for so many people, including people in our community, to dismiss as trivial. It's only a cake. What's the big deal? Can't you go to another bakery? And what Justice Ginsburg understood is that, this is about being able to go about your life, your day-to-day life, without the fear of being turned away. Without the fear of being told your dollar isn't good enough. Without the fear of being told we don't serve your kind here. And she understood those questions. They were not abstract for her because she lived it. When she graduated from law school and she went around and she interviewed with law firms and she's told, no, we don't hire women, you can have a job as a secretary. She ended up teaching at Rutgers Law School because she couldn't get a job at a law firm, which, obviously today we think of legal academic positions as even more competitive, but then it was really a fallback for her because she couldn't get a job simply because she was a woman. So this was real for her. And it wasn't only that she had lived it herself, right? She had also represented people who were in that position. And this is the thing, I think Shannon said earlier, she had an impact, equal perhaps only to Thurgood Marshall, when you think about the impact on the constitutional guaranteed equality. And it's also true when you think about the progressive members of the court, right? The others all made their career representing the government. She is the only one who represented the little guy on the other side of the V, right? The person who was standing up against the government. So it wasn't just that she had been that person herself, but she made her career representing those people. And I think she very much saw in Dave and Charlie, I think a couple could have been her clients, had she been practicing in that time, right? A couple turned away simply because of who they are. That is the Stephen Wiesenfeld of our time. And I think she very much saw in Dave and Charlie, echoes of clients like Stephen Wiesenfeld or Charles Moritz, another male client she had who had been a caregiver for his elderly mother. So her recognition, her dissent really said, I think, to Dave and Charlie and to all of us, like, I see you. I see what this case is really about. And I'm not going to go along with this. There may be my colleagues may have very good reasons for going along with this, but I am not going to go along with this because I know what this is really about and I know what it's like. And that's not the country I want to live in. The other thing that just, with retrospect, I think worth pointing out about her masterpiece dissent is that she dropped a footnote there where she said that Dave and Charlie had experienced discrimination both because of their sexual orientation and because of their sex. And I mentioned that because, of course, that was the question that then was before the court in Bostock. And, it's just a footnote she dropped there, but she did everything she did with great care and intention. Nothing was accidental. Everything was strategic. And she was signaling, she knew what was coming. And I say that only because, as others have said, it's not just the opinions she wrote, it's the opinions that she joined. And I have no doubt that her thinking on this played a significant role in the way that the Bostock trio of cases were decided as well. And she had foreshadowed that back in 2018.
And if I can,
Ria, I just add to what you just said, that there are only 2 justices on the Supreme Court in the last 40 years who were actually civil rights litigators. There was Thurgood Marshall and there was Ruth Bader Ginsburg. And now there is nobody on the court who ever was a civil rights litigator. And it's a sad thing that we've lost her on that court.
It is. And, if I could add one additional quick point on Justice Ginsburg's dissent in Masterpiece. The majority, the compromised majority in Masterpiece was, basically able to dispose of the case without, I think, by its lights, too much collateral damage by saying, well, 2 people on this multi-member commission that were involved in adjudicating the case below made comments that seemed to us like they may have been anti-religious. So we're going to send it back down and let them basically all sort it out. But the majority also gestured at this idea that Colorado had engaged in discrimination because it had pursued an action against somebody who refused to serve a gay couple because they were gay, but hadn't brought claims against a number of bakers who refused to make religiously themed anti-gay cakes. And the majority said, well, that seems like discrimination. Why is it that, people of faith who suffer discrimination aren't protected, but gay people are? The answer to which, and Justice Ginsburg was quite eloquent about this in her dissent, is that the majority's reasoning was just demonstrably wrong. that the bakers who had refused to make religiously themed anti-gay cakes said, we wouldn't make an anti-gay cake for anybody. We were not discriminating because of religion. Our refusal to serve these folks had nothing to do with religion. It was based solely on the fact that they wanted us to make an anti-gay product that we wouldn't make for anybody. And so it wasn't discriminatory. There was no unequal treatment. Colorado said if you discriminate against somebody because of religion, that's wrong. And if you discriminate against someone because of sexual orientation, that's wrong. But there was no evidence that anybody had actually discriminated against anybody because of their religion. And the majority's suggestion of a false equivalence there, she demonstrated, was mistaken. And the reason that's so important, and the reason I think it's worth highlighting, is twofold. The first is that there has recently been in conservative legal circles, in my view, a quite offensive effort, and I say this as a person of faith, an offensive effort to suggest that any time a person wants to engage in anti-gay or anti-trans discrimination, that is so inherently religious in nature that a refusal to go along with it somehow evinces anti-religious animus. That's preposterous, and it's demonstrably offensive as a theological matter, let alone as a constitutional matter. And I think Justice Ginsburg called the majority on it very effectively and made it clear, there is a difference. There is a difference between actual religious discrimination and refusing to go along with anybody who's trying to injure gay people and trans people just because they are gay and trans. The other thing that she has done in not just the masterpiece dissent, but in a whole string of dissents, is refuse to be a part of the radical revision of the religion clauses of the Constitution that the conservative majority on the court has gone along with, has been engineering, and that Justices Kagan and Breyer have gone along with almost in its entirety. That even as the conservatives on the court and even as two of the supposedly more left-leaning justices have essentially gutted the Establishment Clause and have rewritten the Free Exercise Clause in ways that have made it the single greatest threat in the country in constitutional law right now to the rights of LGBTQ people. Justice Ginsburg and Justice Sotomayor have made it clear that the entire direction of that jurisprudence is mistaken, that it is without foundation in the last half century of precedent, and that the court needs to adhere to a correct understanding of the religion clauses, which does not confer any kind of right to discriminate and which takes Establishment Clause principles seriously. And so I think that dissent by Justice Ginsburg in Masterpiece, which can be, I know, a little overlooked because the majority had 7 justices and really held the field, that dissent drew a bunch of lines. It drew a bunch of lines that are profoundly important and that reflected her commitment to actually protecting religious freedom, but doing it the right way and not as part of some larger constitutional project aimed at authorizing discrimination. And in that respect, I think it really was part of and foresaw a path that we're now seeing the fuller realization of at the court.
3 cheers to you, Joshua, because the court is destroying the Establishment Clause jurisprudence of this nation. And you're totally right. And her absence from the court is going to be felt on that score.
Let's maybe shift to something less depressing, and that's Bostock just this past June. One thing I'll say about Bostock, just in terms of talking about oral arguments again, I was at the argument and there was a lot of scary health news about Justice Ginsburg the prior summer in 2019. And I remember coming out of Bostock just thinking she looked and sounded great. I had gone to Obergefell, Masterpiece, and then Bostock. And I actually thought she looked the healthiest and strongest at Bostock, maybe strangely enough, because we now know how many health challenges she was facing at that time. But she was throwing out obscure, talking about the facts of really obscure gender discrimination cases from the 70s with no problem. And it was just, it really made me feel good in that argument, hearing from her and hearing her at top of her form, I felt, during the argument. And then fast forward to June, we got this decision. And again, she didn't write it, Justice Gorsuch wrote it, but a sex discrimination decision that then brought in the LGBT community within the umbrella of sex discrimination. So I think it was also a key a key part of her legacy this past June in her last term on the court. Does anyone want to add anything about sort of what?
Yeah, I do. So Laura Brill and I, so Laura's a lesbian lawyer here in Los Angeles, and she and I were co-clerks for Ruth Bader Ginsburg. And in 2002, we filed the very first brief in the Supreme Court arguing that discrimination against gays and lesbians was actually sexual orientation discrimination. And we represented Now Legal Defense and Education Fund, which today is called Legal Momentum. And so it was a women's rights organization, and we represented them, and we wrote this argument explaining that discriminating against gay people was sexual discrimination. It was discrimination based on sex. And of course, it went nowhere. I mean, today it's the law. But Shannon, do you remember when we did the California marriage litigation, we made this argument in depth. And by the way, Ria, we were also co-counsel with the ACLU. So we argued in the California Supreme Court that discrimination based on sexual orientation was discrimination based on sex. And we were laughed out of the court. All 9 of them ruled against us. Nobody agreed with us. Not even, there was at that time, so today the California Supreme Court is majority Democratic appointed, but at that time there was only one Democratic appointee. Everyone else was a Republican appointee, but all of them ruled against us on this question of whether discriminating based on sexual orientation was a form of sex discrimination. They just laughed us out of court, like, what the heck are you arguing? Nobody ever took it seriously. And can you believe it? The U.S. Supreme Court held it this year, that discriminating based on sexual orientation is sex discrimination. Sometimes it just takes time.
Yeah.
There's a Mariah Carey song that goes along with that, but that's another story.
Yeah, no, it was a real struggle through all of the marriage litigation to foreground the sex discrimination arguments, and we got a lot of pushback for that. But it was very, of course, to see that theory or vindicated in Bostock was wonderful. But even in Obergefell, although the court didn't expressly rely on a sex discrimination argument, at Ria, as you pointed out earlier, there's a huge chunk of that decision that goes through all of the sex discrimination that previously characterized marriage and talked about the elimination of gender-based rules in marriage and discrimination against married women. And all of the kind of foundation is there for the court to have relied on a sex discrimination argument if it wished to do so. And even though it didn't connect the dots, it was clearly a powerful theme and resonating in the justice's mind. And then, yes, it is. I'm so glad that Justice Ginsburg did get to be on the court and see the outcome of so much of her just thinking and analysis and litigation. I mean, what an extraordinary life. I mean, how many people get to first establish these precedents as a civil rights litigator and then be sitting on the court and actually citing cases that she herself brought and won. It's a truly, what a magnificent individual she was, and how much we all owe her a huge debt of gratitude. Particularly, I mean, the LGBTQ rights movement is just unthinkable without her legacy.
Yeah, Matt, I see that you look a little pained, I think because we're running low on time and you're desperately trying to moderate the rest of us. And so I think I apologize on our collective behalf for how unruly we've been.
No.
So I think we have maybe 5 minutes. Did you have a thought about what we might address?
Yeah, there is this, I guess just 2 things. There's this Fulton case coming up to be argued in November. If you could, I know you're involved with it, Joshua, if you can give us some thoughts about that. And then also, there was this really ominous, I guess it was not quite a dissent because they agreed that they didn't want to hear the case, but the statement from Justices Thomas and Alito last week about Obergefell that I think has scared a lot of people in terms of what they wrote. what it might portend. So I guess I'd just like to hear from folks about Fulton and what might be coming.
Sure. We'll end on an uplifting note. No, well, maybe I can quickly address those 2 points, and then if someone wants to share maybe a broader thought on Justice Ginsburg's legacy to close it out. So let me, if it's okay, I'll take a stab at those first 2 points. The Fulton case, in which I'm among the counsel to the city of Philadelphia, and which Shannon mentioned earlier, is a case in which the city of Philadelphia partners with private foster care agencies to identify and certify, prospective foster care parents, and which is part of its larger set of relationships with private entities for foster services of various kinds. And one of the entities with which it partners is Catholic Social Services, which is, as its name suggests, a religious organization, Catholic one. And the city, there's a sort of background story to this, which is that the city learned that certain religious providers in the city refused to serve otherwise qualified or any same-sex couples. And the city understood that to be in violation of the contractual agreement that it had with these providers, who were using city money to administer a city program by city rules for city residents. And it went, and it basically, so it cut off intake, and it basically said, look, if you're going to have this contractual relationship with us to do this, you need to adhere to the terms of the contract, which includes the non-discrimination term. And CSS went to court and sued and lost in both the district court and the Third Circuit on the theory that they were constitutionally exempted under the free speech clause and the free exercise clause from their contractual agreement with the city to not discriminate. That contract has by its terms expired. And so now the question is slightly reformulated. It's whether they are entitled to receive from the city a contract that doesn't include a non-discrimination requirement, or if they sign such a contract, whether essentially they're constitutionally entitled to ignore it. The case has huge potential implications for gay rights, for LGBTQ rights, but also for many other issues, because underlying this is the question of whether religious entities are constitutionally entitled to partner with the cities for the administration of public programs. And then if their religion so requires, to ignore terms of those contracts, including non-discrimination requirements, in how they administer programs that are public programs funded with public monies meant to serve all the public. And so it's a case with profound implications for the LGBT community in particular, and certainly in Philadelphia, where this is an effort to basically write anti-LGBTQ discrimination into the foster care system against the city's will. But it also has much broader implications for the law of religious freedom and efforts to create what's occasionally described as a right to discriminate, but not just a right to discriminate in general, a right to voluntarily sign up for government contracts and programs to take the government's money and to then still discriminate in violation of the terms of the contract that you signed. So Fulton is a case with big implications. That's going to be argued the day after Election Day. So in case you weren't worried enough about November 3rd, you can also worry about November 4th. The other question that you asked was about the recent dissent from, or I guess, I don't know if it was a dissent, the recent opinion at the cert stage. I guess it was a concurrence and a denial, or a statement concerning the denial by Justices Thomas and Alito, in which they picked the case of Kim Davis, of all people, a county clerk who refused to do her job and by providing certificates to same-sex couples. They picked Kim Davis's case as an opportunity to say, Obergefell, has resulted in all of these religious freedom issues, and to pretty strongly imply, so therefore we should overturn Obergefell, which, look, it's not surprising that Justices Thomas and Alito feel that way, but it's still pretty startling that, so quickly after the opinion, they're already at bat looking for opportunities to put out into the world the idea that it should be overturned. This is the same conservative majority that has launched quite an assault on precedent about precedent, and that is seeking to dramatically revise the law of stare decisis in general. And so, I think whether or not this leads to any kind of direct attack on Obergefell, and like to say Obergefell has engendered reliance interests is like saying the sun is warm. So, that'd be a pretty dramatic thing to do. Even if it doesn't lead directly there, I think it's very much part of a broader constitutional agenda as reflected in the manner in which they chose to frame the conflict, to bring religious freedom principles in particular to bear, not as principles that vindicate principles of equality and liberty for all Americans, but instead as the tip of the spear in a conservative assault on the constitutional and statutory architecture of LGBTQ rights. And in that respect, I think the opinion is very much a sign of things to come and of the battles that our community still has ahead of it. So,
yeah, and I do think we have to be vigilant, but I do want to say that Obergefell is 5 years old, and I don't believe that marriage equality is going to be overturned in this country. However, we see with the assault on Roe v. Wade that we have to stay vigilant. We just have to keep staying vigilant. However, people are getting used to the fact that people are gay and they form relationships and they form families, and their families are completely normal. And I do take comfort from the fact that Justice Roberts, even though he wrote a dissent in Obergefell where the last sentence says the Constitution has nothing to do with this, has not ever acted contrary to marriage rights since then. And but we have to stay vigilant. I mean, like, look at the battle over Roe v. Wade for 40 years, right? Like, it was decided by the court 7-2, and we're still fighting over it. It's something that we have to stay vigilant about, and we just have to be on top of it. I just want to conclude one thing by saying that Justice Ginsburg understood something so fundamental that was so strange to her time, but that is so normal now, which is that whether you're a man or a woman or anything else, it just doesn't matter. That you're entitled to live your life and to form your life, to form your family, to form your career, to do whatever you want to do, equal opportunity. It doesn't matter based on how you were born. And she saw that, and that was her life. And she created that in our law. So the Equal Rights Amendment failed, but she got it adopted by the U.S. Supreme Court. She really was a pioneer, and she saw everyone for who they were, and she didn't care what your gender was. It just didn't matter to her.
Ria and Shannon, any final thoughts on RBG or the road ahead?
I think David said largely what I was going to say, which is that the measure of her success is that we would not recognize the world that she inhabited not all that long ago. It's unthinkable today to imagine, a state statute that expressly preferences fathers over mothers in that way, right? You hear it, and it's hard to imagine that it was just in her lifetime. And as I said, that when she brought the case to the United States Supreme Court, a betting person would have said that she would lose because everybody who came before her had lost, right? She had sort of the righteousness of her convictions. She had the women's movement behind her. She had Pauli Murray behind her, and she brought all of that to bear, and she changed this Constitution, and she changed this country. I also wanted to say, Matt, when you talked about her taking the bench the day after her husband passed, you'll remember that earlier this year, when oral arguments were heard in the case involving religious exemptions from the requirement to provide contraception coverage, she participated in an oral argument from her hospital bed. And I think about that as we think about the path to November and what's ahead. I think about the fortitude that she had when she was 39 years old and the fortitude that she had when she was 87 years old. And I challenge each of us to bring that fortitude every day between now and November 3rd. And for you, Josh, November 4th.
Good luck, Josh.
Don't worry, we'll all be super well rested and have nothing else on our minds.
And I would just add, she did change the world. And I think we will be understanding and appreciating her legacy for our lives and our country for a very long time to come.
Guys, thank you all so much for taking the time to do this this panel this morning. It means a lot to me, and I think it'll mean a lot to the wider LGBT community to be able to watch this and think about all the points that were addressed. I really appreciate it, and thank you once again.
Thank you.
Thank you.